SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this current affair class. This is class number 23 and again we have come up with an important topic in this current affair which will be helping you in your upcoming prelims examination. So Elon Musk and his X, this was also known as Twitter, has approached the Karnataka High Court against one section or the move of the government there's a notification which was brought by the government to block the content, and against this order, this notification, X has approached the Karnataka High Court. So three important sections we are going to see to understand what the issue is all about. Section 66A of the IT Act. This is not Income Tax Act, okay? This is Information Technology Act of 2000. This particular section 66A was scrapped by the Supreme Court in the Shreya Singhal case. You remember that? It was held unconstitutional, infringing upon the fundamental right of freedom of speech and expression of the citizen. So it was declared unconstitutional. There is a similar kind of section in the same act, section 69A, which also gives the power to the government to block or remove content. Okay, government can block or remove content, but it also provides a safeguard that if government has to do something like that, then it has to be done on reasonable ground. It has to be done on reasonable ground. The restrictions has to be reasonable. Article 19(2) is important here. This is one of the article which is defining the reasonable restriction on freedom of speech and expression. Okay. In Shreya Singhal case, when the court scrapped 66A, it also said something about section 69A, that if any content is blocked or removed from the intermediary app such as X, then of course it has to be done on a reasonable ground and can be done after the order of the court or when the government notifies. Of course, the notification has to be reasonable. It cannot be arbitrary. I hope you have understood. Now, there is another section which is important to us. Section 79. It is a safeguard to the intermediary app or intermediary platforms like X, that if a third person if somebody puts something on Twitter, he writes or she writes something which is very offensive, which is obscene, which is immoral, which is against the unity and integrity of the nation. So it is not the responsibility of this particular intermediary platform X, but is the responsibility of the third person who is posting it. Okay, but at the same time, if you see this section 79 subsection 3 clause B, it gives power to the central government to remove such content after the court's order or after the notification of the government. I hope you are getting this much. Now, once X has been notified or an intermediary has been notified that such content has to be removed from your platform, and if the intermediary does not take any action in that regard, then the government can block it. So a government recently has brought this notification which we are talking about. The notification under section 79(3)(b) to block content which is there on X. This notification has been circulated to all the ministries. Against this notification, X has approached the Karnataka High Court. What is the plea? On what basis has X approached the Karnataka High Court? It is saying that there are safeguards available under section 69A. That whatever has to be blocked or removed has to be reasonable. Okay, I mean the grounds has to be reasonable. Okay, so what the plea is saying or what the petition is saying, that the notification which is passed by different ministries to block content on the intermediary sites or intermediary apps does not follow the procedure given in section 69A. I hope this much is clear to you. And that is why intermediary platform like X has approached the High Court. Now we are going to see what's there in the slide. So Elon Musk's X, formerly known as Twitter, has challenged section 79 of the IT Act, which government used to moderate or order the removal of content in the social media. They are saying that whatever notification the government has brought under section 79 has to conform to the safeguards given under section 69A, which are reasonable restrictions. The restrictions has to be reasonable. Section 69A, as we have already seen, it governs the content blocking by the government, allows content to be blocked only if deemed necessary on grounds such as sovereignty and integrity of the country, security of the state, public order, decency and morality. And the blocking orders must record reasons. This is important. How can a notification of the government become reasonable, logical, based on some ground and non-arbitrary? Only when the government records the reason, subject to the judicial review. That whatever reason is written by the government to block a content on the intermediary website or app will go for judicial review, and the judiciary has to confirm positively to that removal. Then only the removal can be done. It is a very important provision for the upliftment of the rights, such as the right to freedom of speech or expression, or else government will come up and try to block everything which is there, which will be against the freedom of expression in the country. That is why this safeguard has been given. 69A, very important for your examination, is a very important part of freedom of expression. Shreya Singhal case, we already know. 66A was scrapped, which quashed section 66A of the IT Act. 69A became the primary law governing the matters relating to blocking any information generated, transmitted or received or stored or hosted in a computer source. I hope you get it. Now, again, section 79 of the IT Act, this provides safe harbor to the intermediaries like X. It in one or the other way saves platforms like X from getting affected by the posts made by a third party. Okay, if somebody is posting anything which is obscene, somebody is posting anything which is against the unity, integrity of the nation or which disturbs the public order, X is not responsible for it. That thing, that safeguard is provided by section 79, but the same section 79 subsection 3 clause B gives the power to the government to block the content when the intermediary has been notified by the government that such content has to be removed. And one more thing to understand here is, when government notifies the intermediary to remove some content, why X went to the High Court? That whatever notification which is coming from the government, whatever communication which is coming from the government to remove the content, that has to be reasonable. It should apply the procedure given in section 69A. That's the only thing which has been dragged into the court. Now, party type, if you see, what is this first party, what is this second party, what is this third party? Okay, so it's a very important for you to understand. So what is first party? The platform itself, what we are calling as intermediary, provides the service, hosts users and content. X, Twitter, this is intermediary or the platform. This is important for you to understand. The user directly using the platform is known as the second party, people like you and me who are using Twitter or X. And third party is any external user or entity whose content is hosted. Okay, what is the role? It originates the content that is under question and is impacted by it. So that is the third party. So if any third party posts anything on intermediary, see this first party, then under section 79 a safeguard is provided to the first party, but at the same time under subsection 3 clause number B of the same section 79, the government can direct the intermediary or the first party to block that content, but that has to be done on a reasonable ground following the procedure given in 69A. So X's argument against government's use is same. X claims that the use of section 79(3)(b) to issue blocking order circumvents section 69. So whatever order the government is issuing has to come through the prism of safeguards given under section 69A. Okay. Violation of Supreme Court's precedents. So there are several precedents which are given in Supreme Court by Supreme Court where safeguards under section 69A was used to block something or to not block something. That is also violated under this notification. So government, what it has done recently, the Ministry of Electronics and IT directed all government bodies to issue blocking orders under section 79(3)(b). In 2024, it launched a centralized portal, Sahyog, to streamline such blocking orders. So on a mass level, the government is trying to block the content on intermediary apps, intermediary websites such as Twitter, such as X, and they are considered as infringement on the right to freedom of citizen, and that is the reason why the X has approached the High Court. The only argument which X is making is these notifications or these orders which are passed by the government, they are okay, but it has to be passed according to the procedure given in section 69A. The procedure simply says one thing, that whatever orders or notifications you are passing has to be on a reasonable ground. It has to be a reasonable restriction. It cannot be an arbitrary restriction. So I hope you have understood the whole idea of this video lecture. So thank you very much for joining me, and next time we will come up with the next lecture which will be helping you in your upcoming prelims examination. Thank you very much. Have a nice day and Jai Hind.